Hi, I'm Gary from Westwood Estate Planning. Are you thinking about a lasting power of attorney but feel a little bit overwhelmed by all the information out there? Perhaps you've had some fundamental questions about what an LPA really is or what happens if you don't have one. In this video, I'm going to answer the top 5 questions we hear most often about LPAs, giving you the clarity you need to move forward. We'll cover what LPAs are, critical consequences of not having them in place, how to choose your attorneys wisely, when LPAs actually become effective, and the key responsibilities of those acting on your behalf. So let's start with the basics. Seems a good place to start. A lasting power of attorney, or LPA, is a crucial legal document that allows you, while you still have mental capacity, to appoint trusted individuals known as attorneys to make decisions on your behalf if you ever lose the ability to do so yourself. It's about ensuring that your wishes are respected and your future is protected. Now, there are 2 distinct types of LPAs, a property and financial affairs LPA, and this covers decisions about your money and property, such as managing bank accounts, paying bills, or even selling your home. Your attorneys can act under this LPA either before or after you lose mental capacity, as long as it's registered. Now, the second type is a health and welfare LPA. This covers decisions about your daily routine, medical treatment, and even where you live. Importantly, attorneys can only act under this type of LPA once you have lost mental capacity. Anyone over the age of 18 with the necessary mental capacity can create an LPA, and it's a significant decision, truly benefits from professional discussion to ensure that it is tailored to your unique circumstances. So, question I hear quite often, what happens if you don't have an LPA? This is perhaps one of the most important questions, and it highlights why LPAs are so vital. If you lose mental capacity and haven't put an LPA in place, your loved ones won't automatically be able to manage your affairs. Instead, someone will have to apply to the Court of Protection to be appointed as what's known as a deputy. Now, this process comes with several significant disadvantages. So, number 1, loss of choice. You don't get to choose who acts for you. Ultimately, the court decides. Now, it can be costly. So, there are application fees, assessment fees, and ongoing supervision fees, which can mount up and be substantial. Time consuming. So, obtaining a deputyship order can take anywhere from 12 to 18 months, leaving your affairs in limbo during that time. Also, a lack of control. The deputy is supervised by the court, and their powers may be more restrictive than those granted in an LPA that you've put in place. So in stark contrast, creating and registering an LPA is considerably quicker, typically taking it around 10 to 16 weeks for registration, and significantly cheaper. It ensures you maintain control over who makes decisions for you and how they do, even if you've lost capacity. So once you've decided to create an LPA, a critical choice is how you appoint your attorneys. This isn't just a legal technicality, it has huge practical implications for how they can act on your behalf. You can appoint them in 3 main ways, jointly and severally, or a combination of both. So let's focus on the 2 most common ways to appoint attorneys. So firstly, jointly. If you appoint your attorneys jointly, it means they must all agree and act together on every single decision. The major pitfall here is that even if just one of your jointly appointed attorneys becomes unable to or unwilling to act, so perhaps they're unwell, on holiday, or even if they themselves have passed away, the entire LPA can become unusable unless you've appointed a replacement to step into that specific role. This can force your family, into costly and time-consuming court of protection applications that we've just covered. So second, jointly and severally. This is often the third method for flexibility. It means that your attorneys can act separately or together. If one of your attorneys becomes unavailable, the others can continue to act without interruption. This provides much greater resilience and ensures your affairs can always be managed efficiently. Thoughtful attorney appointments is truly critical, and considering replacement attorneys is also highly advisable to prevent your LPA from failing. A common misconception is that an LPA is effective the moment you sign it. Now, that's not quite right. For an LPA to be legally valid and usable, it must be registered with the Office of the Public Guardian, or what we now refer to as the OPG. The OPG is the government body responsible for registering LPAs and supervising deputies. So here's a quick overview of when your attorneys can act. So Property and Financial Affairs LPA. Once registered, your attorneys can act on your behalf either while you still have capacity, if you choose to do so, or after you lose it. This flexibility can be very useful for managing your affairs if you're, for example, traveling for an extended period. So the second type, Health and Welfare LPA. Now, this type of LPA can only be used once you have lost mental capacity to make those specific health and welfare decisions for yourself. The registration process can take several weeks, which is why we often advise clients to register their LPAs immediately after creation. This ensures the documents are ready to be used the moment they're needed, providing continuous control and avoiding potential delays during a crisis. So being an attorney is a significant responsibility, and it comes with clear legal duties. Your attorneys must always act in accordance with the Mental Capacity Act 2005 and have regard for its code of practice. So their key responsibilities include 1. Acting in your best interests. Every decision they make must be in your best interests, not theirs or anyone else's. So number 2, supporting your decisions. They must always try to help you make your own decisions first, even if your capacity fluctuates. The law presumes you have capacity unless it's proven otherwise. Number 3, keeping records. For Property and Financial Affairs LPAs, attorneys must keep accurate accounts of all your money and property. And lastly, no personal benefit. They cannot benefit themselves from their role unless specifically authorized by you in your LPA. It's crucial that your attorneys understand these duties. Ongoing communication with them is vital, ensuring they are prepared and confident in their role should they ever need to step in. So we understand that putting a lasting power of attorney in place is a significant decision, and getting it right provides immense peace of mind. If you have more questions about LPAs, or if you'd like to discuss your specific situation and how Westwood Estate Planning can help you put your robust LPAs in place with clarity and confidence, please click that link in the description below to book your free, no obligation 15-minute chat. We're here to help make the process as simple and as stress-free as possible. So, thank you for watching. I'm Gary from Westwood Estate Planning. Protect your loved ones and secure your peace of mind. I look forward to seeing you on the next video. Have a great day ahead.